with us to log off, please. And
You
you can remain on, but turn off your cameras. That's, I guess, what I'm saying. We're all getting used to tech speak.
And we have Madame Charon is there, and we are waiting for Mr. Bellissimo.
There he is. Okay.
There.
Okay, so we're making a soft transition then to the next, the second panel. And colleagues, we welcome Mario Di Bellissimo, lawyer of the Bellissimo Law Group. And we also welcome Professor Andrea Charon, Director, Center for Defense and Security Studies of the University of Manitoba. Each of our witnesses, I think, have a brief statement to make, so I'd like to thank them for being here. And Mr. Bellissimo, you have the floor. And you are on mute, unfortunately.
Always has to happen.
Of course. Please go ahead.
Thank you. Good morning. Thank you for the invitation to discuss and explore Bill S-8. In our brief, based upon a limited time to review, we make 5 recommendations we hope will advance the study and decision-making surrounding the bill. So why the recommendations? Well, the result of more restrictions in the IRPA, expanded sanctions encompassing countries, entities, and persons on new economic, geographic grounds, etc., and perhaps even in the absence of any personal wrongdoing, adds to unease regarding the equivocality, scope, and practical application and administration of the bill. So our first recommendation is the requirement for legislative clarity regarding the definition and legal scope of sanctions. As we heard earlier today, the international or multilateral sanction has been in place in the IRPA for 20 years, and for the Special Economic Measures Act, SEMA, and the Justice for Victims of Corrupt Foreign Officials Act for about 5 years. Make no mistake, the current law is very robust and restricts access to most any immigration and refugee status for foreign nationals and their families, but there remains limited remedial rights under the Act. Now, Bill S-8, based on our reading, expands and contracts the inadmissibility provisions. It separates the word sanction, the word sanctions, as a standalone, divorced from now grounds of violating human or international rights. It further expands the grounds for inadmissibility pursuant to all of Section 4 of the SEMA in 2 material ways. One, it includes economic measures against a foreign state. And B, and I'm paraphrasing, as a result or potential result of grave breach of international peace and security. It also eliminates all access to the Immigration Division and or ministerial relief. So there would be no hearing permitted, which is now permitted for those subject to international sanctions. At the same time, the bill permits full eligibility to make a refugee claim and ceases inadmissibility if sanctions, et cetera, are rescinded. We endorse these final 2 amendments. Still, though, a number of questions flow. I'll mention a few. We set out many in our brief, but just a few. Will the word sanctions and the word entity be defined for the purposes of the IRPA and the regulations? It's unclear why the new proposed Section 35.1 of the bill cannot simply be aligned with the current wording, which should read sanctions for human or international rights violations. Will the human or international rights violation still be a requirement? And should the same legal consequences under the IRPA result regardless of personal wrongdoing? This is all very important because subject matter experts in the Canadian sanctions regime, like my esteemed co-panelist, Dr. Charon, and a prior Senate study that was referred to today, raise a number of acute issues with the sanctions regime, too many to recite here, but include the need for parliamentary oversight, better coherence and compliance, timely and independent redress avenues, accountability, transparency, and other practical challenges. Put plainly, if even a few of these concerns persist, moving forward on this sanctions foundation could negatively impact many individuals that the law was not intended to capture, including children. Equally troubling, though, it may not exclude the bad actors because the law becomes immersed in legislative ambiguity and applicatory limitations, resulting in procedural and fairness concerns and potentially even rising to the level of constitutional concerns. Given all this, we recommend the same legislative clarity under Recommendation 2 for the Citizenship Act and the Emergencies Act. As for Recommendation 3, given the legal and practical challenges at play, we recommend timely access to ministerial relief and the Immigration Division remain in place, perhaps even explored safety valves to the Immigration Appeal Division. It is a complex spider web. Just one example, Canada continued to leave sanctions in place against a foreign state like Liberia long after the United States lifted them. What happens to a Canadian citizen or permanent resident or foreign national or dependent family member in that scenario under citizenship and immigration law? So recommendation 4, we underscore the need to resolve potential unintended consequences for dependents. If recommendation 3 is adopted, it would assist in minimizing concerns regarding potential overbreadth. Finally, recommendation 5, we rely on David Mattis's brief, which I understand is before the Senate. Granting of refugee status should result in immediate delisting, and access to refugee status should be uniform in and outside Canada. These recommendations, in our view, will better facilitate the harmonious intersection of Bill S-8 with other domestic and international legislation, so the context, the object of the acts, and the clear intention of Parliament are ultimately realized. Thank you.
Thank you very much, Mr. Bellissimo. We will now go to Dr. Charon. You have the floor.
Thank you very much for the privilege to provide my thoughts. The trend in Canada has been to create new legislation to fix sanctions issues, but the issues are often not a problem of legislation, but of process and policy. First, what is the problem these changes are trying to fix? Was there a case of a foreign national under sanctions who was inadmissible, who gained access to Canada? And based on the testimony today, this seems not to be the case. If it were, it'd be appropriate to ask, was this the fault of the legislation or enforcement or some other factor? The ERPA could accommodate inadmissibility due to sanctions before these proposed changes. So this legislative change, I suggest, would benefit from a requisite policy review. Second, does Canada want every foreign national targeted under CIMA to be inadmissible automatically? Or does the Canadian government want the continued ability to layer sanctions and to delist in stages 2? What is more, CIMA is usually used to stigmatize whole states, these geographic sanctions. And so in the absence of naming any individuals, which we may not wish to do for a variety of reasons, or Canada may be slow to produce a list, it's not clear to me what inadmissibility means in this context, and if this would make it more or less likely that Canada's sanctions would align with our allies. The main policy and process problems are that Canada is not always clear about the reasons for sanctioning or the conditions to be met for their lifting. This is because the triggers for imposing regulations versus the reasons for listing individuals under the CIMA do not need to correspond. This means then that the value of sanctions, i.e. in communicating to the target the transgression and desired outcome, are fuzzy. For example, while a regulation may be implemented due to gross and systematic human rights violations in a country, an individual may be listed for being a senior official in the governing regime in which a grave breach of international peace and security has occurred, and that has resulted in or likely to result in a serious international crisis, which is the case for many listed under the CIMA under the Russian regulations. On the one hand, the changes proposed make it clearer that a foreign national can be inadmissible if under sanctions. On the other, it does not change the fact that the communication and coordination of sanctions still need strengthening. The problem is the reason to sanction is not clearly articulated. Further, there is still no icon on the Global Affairs website to indicate to look for inadmissibility other than to know to look for the ERPA. Canada does not inform targets that they are sanctioned, and Canada still cannot sanction entities under the JVC-FOA or the Magnitsky Act. Rather than making piecemeal changes to legislation, and given the fact that autonomous measures shall be applied more and more in the future, given paralysis at the UN Security Council, I have 7 suggestions. First, a comprehensive review of the CIMA and the JVC-FOA as noted in Section 16 of the JVC-FOA, given the 5-year anniversary of changes to both, with particular focus on the progress from the Standing Committee on Foreign Affairs and International Development's report, which had 13 recommendations to improve the effectiveness of Canada's sanctions is needed. 2, tell targets they are sanctioned, as does our allies like the EU. 3, a review of the quality of the evidence used to name targets and entities is needed. It is publicly sourced evidence, yet we do not list birth dates, passport numbers, as does the UK and EU, even if our names are the same. Next, Canada's consolidated list is still too cumbersome to search, and Canada does not provide any push notifications of changes, as does our allies. Next, we need to signal in CIMA under Section 4.2 and in the JVC FOA under Section 3 under restricted prohibited activities that inadmissibility is a possibility. And lastly, while freezing foreign assets of Corrupt Foreign Officials Act, or the FACFOA, is not considered, and they are not considered sanctions per se, if one can be inadmissible for corruption via the CIMA and the Magnitsky Act, why not for the FACFOA? While there's nothing wrong with highlighting in the Immigration and Refugee Act that inadmissibility due to sanctions is possible, this repeats a pattern whereby Canada tinkers on the margins of legislation without addressing core policy and process issues. If we're to continue to sanction autonomously with allies, we need to fix fundamental issues of policy and process.
For your comments, and I'd like to thank you both for very useful statements. Colleagues, I have Madame Lemay and I have a list here, but there are no names on it. La sénatrice Gerba, s'il vous plaît.
Senator Gerba, please, you have the floor. Thank you, Mr. Chair, and thank you to our witnesses. My question is for Mr. Bellissimo. Mr. Bellissimo, Section 6, subsection 2 of S-8 specifies that a person no longer under sanction will no longer be held inadmissible. Do you think that this clause suffices to include the reversibility of inadmissibility when a person is no longer sanctioned?
Oh, please.
Thank you for the question, Madam Senator. It's helpful that inadmissibility ceases upon a sanction being removed, but the problem that occurs in that scenario is where does the sanction have to be removed? We just heard from Dr. Sharon about the difficulties related to push notifications. Is the sanction removed? Is it removed by the United Nations? Is it removed by Canada in concert? And how long does this process take? So our concerns by infusing this entire regime in the immigration and inadmissibility scheme as it currently reads, it just infuses incredible uncertainty as to who and why people are affected by it. How long will the delisting process occur? When someone is tied up in that, if it's, let's say, what we now have with ministerial discretion under the IRPA can take 3, 4, 5 years. If we're talking about putting people's lives on hold, children, dependents for that long, we need clear legislative clarity to understand what happens and when. Right now, in our reading of the Act, it's skeletal. It gives us some indications. The main question we need answered is, are we divorcing sanctions from international and human rights violations? And if that divorce is intentional, what does it mean in law? Does it mean that anyone from a certain geographic region is going to be sanctioned regardless of personal wrongdoing? Well, we heard today that an individual and an entity would be listed. That's helpful, but clearly a dependent wouldn't be listed. So what about them? So there's just, and I can go on and on, but we get into a snakes and ladders scenario that I think, given the importance of this legislation and given the challenges we're facing, we need to be a little more refined and clear so we don't get caught into a legislative battle and interpretive challenges over the years. Thank you.
Madame Sénatrice,
Yes.
vous avez encore 1 minute.
Madam Senator, you have 1 minute left. Yes, thank you, Mr. Chair. I would just like to know whether these sanctions that prevent freedom of movement, are they really an effective way to induce people to change their behavior?
Mr. Bellissimo.
Is that directed to me?
elle pourrait s'adresser.
Well, it may go to Dr. Charon as well, if she has something to add.
To Dr. Sharon then. That's all right. Dr. Sharon.
Well, thank you. It potentially can be, but there's no one magic sanction that is going to make anybody, least of all the Putin regime, sit up and think, I need to rechange my foreign policy. It's usually the layering of sanctions and doing it in concert with allies, but it takes time. Certainly, travel sanctions in the past, for example, when Charles Taylor from the Democratic Republic of the Congo and his family were sanctioned, that did change his calculus, but it's all about having those targeted sanctions. And so they need to be different for each regime and each sort of change in behavior we're trying to achieve.
Thank you very much, Merci,
Merci.
Senatrice. We go to Senator Wu.
Yeah, thank you, Chair. My question is in the spirit of trying to get our witnesses to say a bit more to help us understand the problems that they see in this bill. As I understand it, they are telling us that this bill is a solution to a problem that doesn't exist. And yet there are problems in the sanctions regime prior to the question of inadmissibility that need to be addressed. And these problems have to do with imprecise definition of why the sanctions were imposed in the first place. I'm offering a précis which may be inaccurate, and I do it partly as a question, but mostly to get you to talk a bit more about what we need to be thinking about on this bill perhaps, but more broadly about challenges and difficulties in the sanctions regime.
Thank you. Let's go to Dr. Sharon first, followed by Mr. Bellissimo. Dr. Sharon.
Thanks very much. Well, I have been asking for a review of our sanctions machinery and architecture for years because we just keep layering on more legislation. And yet, for example, the Magnitsky Act hasn't been used in 3 years now. We cannot target entities under the Magnitsky Act. There's still confusion about what exactly property means. The fact that, the penalty is $25,000 for the CIMA and the JVC FOA, but $100,000 for the UN Act. There are so many sort of questions that, especially because sanctions are given effect by third parties. It's banks, it's real estate agents, it's individuals, it's university administrations that have to be aware of how sanctions work and know when to raise the red flag to say, I think perhaps there's somebody who should be looked at a second time or not. And so that's why, rather than, again, changing the legislation, and I note there's another change being advocated by another senator to the JVC FOA, I really think we need to pause and think in terms of how can we make our legislation work with our allies, because in this age of geopolitical strategic competition, and the UN is no longer the primary sanctioning authority, these autonomous measures have to be done in concert. And we know there are very different pieces of legislation at work, but there are ways through policy, process, and coordination we can make the sanctions more effective. Finally, sanctions, the goal should never be quantity. It should be about the quality. Whom are we sanctioning? With what measures? And be very clear about what we need them to do to lift the sanctions, not just, as is the case, they were sanctioning because you're doing bad things. That gives them no direction in terms of, well, what do you want us to change?
Thank you, Dr. Sharon. Mr. Bellissimo, you have a minute and a half.
Thank you. Senator Wu, at its core, the key issue is that as the law reads right now, someone who commits gross human and international rights violations is being treated the same way potentially as someone who's engaged in no wrongdoing at all through the immigration lens. And that to me is unacceptable. And it's something that could plague someone for years and years, their children. And we talk about there not necessarily being a policy change, perhaps, but there's tangible changes here. We're not even allowing these individuals to access the immigration division any longer. We're not allowing these individuals to access ministerial relief. So at the same time as we ratchet up like just a blanket consequence, we take away procedural fairness rights, potential refoulement for refugees, even under the Emergencies Act, potential immediate removal. These are serious, serious considerations, and you need nuance, you need scope, and you need scale when you're trying to implement. I am not a sanctions expert like Dr. Sharon, but looking at this and thinking of how it's going to apply day to day on the ground with individuals trying to navigate, the consequences are incredible. So I urge all lawmakers to think about the unintended consequences, because there are many and they are far-reaching. Thank you.
Thank you very much. Thank you, Senator. We'll go to Senator Omidvar, followed by Senator Richards. Senator Omidvar.
Thank you, Chair. Professor Sharon, I appreciate really the need for some kind of review and alignment. And I think I'm not a member of this committee on a permanent basis, but I think you've just given the chair of this committee a proposal for a study. You know, they can always work harder. You can always work harder. My question, though, I think is to Mr. Bellissimo, because you have pointed out your concerns on the bill. What amendments would you propose to address your concerns?
And we try to set them out. Thank you for the question, Madam Senator. We try to set them out in our brief, and the proposals are very clear. I think we need a specific definition of sanctions entities, not driven by the complex web of domestic legislation, but one specific to immigration. We need the same for the term entity. We need the same clarity under the Citizenship and Emergency Act. There is actually no reference at all to what any of this means now under those acts. And then, we're dealing with revocation of citizenship. This is at the highest level. We're also talking about stopping citizens from sponsoring potentially because of this. So it affects a lot of people. We'd also look at looking at what are the effects on dependents. So amend that dependents have access to remedial options under the Act, be it the Immigration Division, the Immigration Appeal Division, ministerial discretion. And that ties into our other recommendation is, why are we taking away procedural protections at the same time as we're infusing so much more in terms of consequence? And as we mentioned with respect to refugees, as soon as you're found to be a refugee, as soon as you're found to have some sort of status in Canada, you should be delisted immediately. Should not have to require to go through another process and be further delayed when you've been recognized by Canada.
Thank you.
Thank you.
A follow-up, Senator?
No, except
Okay.
I didn't see the brief, so I apologize for maybe I didn't get it. I'm sorry for having asked you to repeat what you already said, but I think it was worth repeating. Thank you very much.
Senator, the brief is online, so I think you should be able to see it.
Not sure. Okay.
On the committee's page. We'll go to Senator Richards.
Yeah, a quick comment, Mr. Chair. I'm wondering if this. I know that it's a different kind of policy, but my son was on the no-fly zone when he was 9 years old. And it took a while to get. They realized their mistake as soon as they saw this little kid with blonde hair who wanted to travel to Toronto, but still he was on the no-fly zone. And I'm wondering if the same kind of egregious complication could arise with these sanctions.
Who is the question for, Senator? You're on mute.
Oh, sorry, Mr. Bellissimo, if he wishes.
Thank you, Senator, for the question. Absolutely. And there's another, it goes beyond what we're discussing today, but the department's also moving to increasing use of artificial intelligence and a lot of technological assistance. So a lot of these now will be a triage on a certain basis. We're still sometimes getting requests for driver's license for 7-year-olds. So and in my practice, what in 25 years, what is initially intended by legislation and what the application ends up being can be worlds apart and take years to reverse through jurisprudential changes or battling on the ground. So absolutely, Senator, those are the exact type of consequences we should be avoiding. And let's remember the principle of this all is we don't want to allow bad actors to skim through the system or not be caught because the entire scheme is so complex or it's challenged or it collapses. And I urge again the senators to think about that, because the more complexity, the more wild interpretation you can engage in legislation, and less nuanced it is, the more easy it is to challenge. Thank you.
Professor
Thank you
Charon.
very much, and yes, thank you very much, sir. And I do agree. I don't want the bad actors to be able to slip through the system either. But there has to be some kind of guarantee that a kid of 9 years old is not on a no-fly list. So I thank you for that.
Thank you, Senator. I see Professor Charon nodding, and I'm thinking she might want to make a comment on this as well. So if you
I agree completely with Mr. Bellissimo. And further, I think we need to think through the process whereby the information goes from a list created under the jurisdiction of the Minister of Foreign Affairs through now to the CBSA, and how that actually works in practice. Because it's not clear to me, based on the public evidence, how that's happening and why it is that we get so little information on our websites. There may be some very good reasons, but given again that most of the sanctions, the onus lies on other than government